determine that the certification in this area of law is feasible and appropriate, and that we will be drafting appropriate certification standards for review by CBLS and the State Bar Board of Trustees. Again, that is part 2. We're not there yet. So I just want to remind everyone, how the report was prepared and what questions we're responding to today. And wanted to really thank especially Ryan and Lindsay, who took the laboring oar in putting together all of the presentations that each member of our consulting group has prepared and has put on paper the written paper copy of the report that the 2 of them will be presenting today, and we will be presenting to CBLS at their next meeting, hopefully in December. With those introductory remarks, unless there's any questions from the group, we will move on to item B, which is the approval of the June 1, 2023 consulting group on the establishment of a legal specialization in privacy law public meeting minutes.
I move to approve.
Great.
I think we need a second.
Yanaka, second.
Right. Janelle, have you noted?
I have.
The members who have made the first motion and the second?
Yes, I have. For roll call, I have Choi.
I vote to approve.
Davis.
Approve.
Hershenson.
Approve.
Israel.
Approve.
Jaworski.
Approve.
Pillay.
Approve.
Karanian.
Approve.
Froelich.
Approve.
Lanoy.
Sorry, I was on mute. Approved.
Perfect. Martinez.
Approved.
Rajmahan.
Approve.
Serrato.
Approve.
Yanaka.
Approve.
Motion has passed. The minutes have been approved.
Thanks very much. With the minutes have been approved, we will move to item C, which is the chair's report. The Board of Trustees recently adopted a public comment policy that applies to all State Bar committees, including this one. Its policy statement says the State Bar of California welcomes public comment at all of its public meetings and appreciates listening to a wide range of viewpoints that reflect the diversity of California. Those public comment rules are designed to ensure that members of the public may exercise their right to be heard, as well as ensure that the State Bar is able to fulfill its obligation to conduct public business on behalf of the people of California in a timely fashion. Written public comment may be submitted to the email address on the meeting agenda, and we encourage you to submit written public comments at least 24 hours prior to the start of the meeting. Written comments received less than 24 hours prior to the start of a meeting will be distributed the following business day. If you bring written materials to a meeting for distribution, they will be collected by the meeting secretary and distributed after the meeting concludes. For oral public comments, persons were encouraged to sign up to speak in advance of the meeting and will be called in the order that they have signed up. Persons attending the meeting remotely will be called in the order that they appear in the attendee list, and in a moment, I'll explain how to raise your hand to tell us that you want to do that. Speakers cannot cede their time to another speaker. It does not guarantee that all who wish to speak will be able to do so to facilitate hearing from as many members as possible. We encourage you not to repeat points that were made by previous speakers. Simply say that you agree with them to allow the committee the time needed to deliberate on the important topics that we will be discussing today. We'll be limiting public comments to 3 minutes per person. As a reminder, the State Bar's anti-discrimination and anti-harassment policy says the State Bar maintains zero tolerance for unlawful harassment, discrimination, and retaliation. Employees must at all times treat all other employees, job applicants, and persons providing service to the State Bar with respect and dignity in accordance with this policy. Likewise, the State Bar will not tolerate harassment, discrimination, or retaliation against its employees, job applicants, or members of the public by any employees or by any person with whom the State Bar has a business service or a professional relationship. If you are in Zoom and want to speak, you'll need to raise your hand unless you are already on the pre-meeting sign-up list. To do so, you click on the hand icon that's at the bottom center of your Zoom window. If you're participating by telephone, you may virtually raise your hand by pressing *9. That's the star key and then the number 9. Our coordinator will call members of the public, starting with the pre-signups and then the Zoom list, followed by in-person signups in the order that they raised their hands or signed up. Staff will enable the microphones for the speaker, start the timer, and then call out when 30 seconds remain. Do we have anyone that wishes to make comments? Do we have anyone on the pre-sign-up list?
We do not.
Okay. And we do not have anyone currently on Zoom.
No.
Seeing no hands being raised, we will move to item 2, the business of the meeting. Okay. Item 2A. This is discussion and approval of the Privacy Law Consulting Group report and submission to the California Board of Legal Specialization. And I'm going to be calling our Vice Chair, Ryan, and a member, Lindsay, to introduce and to summarize the report that they have prepared on behalf of our group. At this time, I would really like to give a note of thanks to both of them. They have really tirelessly worked on this. This is a labor of love. Two of them have spent, along with the State Bar staff, countless hours in preparing this report. So we really owe them a huge debt of gratitude. Thank you very much, Ryan and Lindsay. Okay, now I will give the mic over to Ryan and Lindsay, who will summarize each section of the report and ask this group for any edits if needed, just so that we can move this along in a productive and efficient way. I think the way that I would like to recommend to proceed is to go section by section. So Ryan will begin with a summary of the first section in the report. Hopefully you all have it in front of you, and we'll ask for the members to provide any edits or any discussion. And if we have none or we have completed the discussion, we'll go to the next section. Ryan, we will send it over to you to start the discussion on the executive summary.
Right. Thank you, Jawan. And I just want to echo what you said about appreciating the work that the bar did on this report. They put in a lot of the heavy lifting in compiling this all together. So it's really appreciated, and thank you for the great work. So starting off with an overview of the executive summary. In September 2021, the California Lawyers Association, the CLA, submitted a letter and proposed a new specialty area for privacy law. The California Board of Legal Specialization adopted the following recommendations. 1, that a state bar privacy law specialization be further explored, and 2, that staff begin working on a proposal to the Board of Trustees for creation of a privacy law consulting group. At its December 17, 2021 meeting, the CBLS approved the request to delegate authority to the CBLS chair to appoint a consulting group. The consulting group was appointed and charged with evaluating whether the CBLS should adopt a privacy law as a specialty area. The consulting group proceeded to identify a need for a privacy law specialization. The executive summary then goes on to recognize the changing privacy law landscape and growth of privacy law section membership at the California Lawyers Association. And additionally, the summary discusses the changing area of privacy law, including the CCPA and the CPRA, and that a need for recognized expertise and competence exists. So do we have any edits or recommendations?
A copy of the report was sent to you previously before the meeting. So we will give a minute after each section. If you don't have any comments or edits, we will move to the next section. Any comments, questions, or edits in the first section? If not, we will ask Ryan to give us a summary of the background. Okay, I don't see any hands. Janelle, let me know if I'm missing any hands. Ryan, please move on to the next section, please.
Okay, so moving on to the background. It discusses the CBLS as a body and where it sits at the bar, how it governs specialty programs and has a thorough evaluation process. Additionally, the CBLS serves as a reliable resource for individuals seeking competent legal representation and refers clients to certified legal specialists. The CBLS aids in fostering trusting relationship between attorneys and their clients, enhancing transparency and facilitating informed decisions in legal matters. The background then goes on to discuss how 2 applications were submitted for interest with CBLS in privacy law, both by the IAPP in 2019 and the CLA in 2021. Both organizations discussed the need and interest in privacy law specialization, and in response to that CLA specialty application, this consulting group was created.
Thank you, Ryan. Do we have any discussion, edits, or changes that we would like to make in this section of background?
No hands have been raised.
Okay. If not, we'll move on to the next section, which is the history of privacy law in California. Ryan?
So for the history of privacy law in California, we have a detailed timeline of privacy law with a focus on privacy law in California as a state and in the United States at the federal level. Major privacy law events are listed in a specific fashion. And without going through the entire timeline right now, it does list the highlights in the report. There's an obvious ramping up of the intensity as more regulation and statutes are passed in recent history, particularly since 2020 in California with the CCPA, the CPRA, and creation of the CCPA, which is now rapidly expanding its efforts and actively implementing new regulations. The history concludes with a recognition that other states are also actively working on their own privacy laws, and practitioners need to be able to perform that analysis, as well as many countries. There's 137 having their own privacy legislation under consideration, and that is a very rapidly evolving legal landscape.
Thank you, Ryan. And again, we're hoping that this section is responsive to the State Bar's question, which is privacy law a sufficiently defined area of law that a specialization will be useful to the community? And I have to reiterate this report that Ryan and Lindsay and staff put together. It really is a combination of all of the group's efforts. And so thanks again for, I know each and every one of you have contributed, and you're seeing your research and preparation showing up in this report today. Do we have any comments or edits on this part of the report? If not, we're going to move on to the next section, which is the necessity of a privacy law specialty. And Lindsay is going to present for that section. Lindsay?
Thank you. And thank you, Ryan. So this next section talks about the reasons why a specialty area in privacy law in California is essential, including that it is a rapidly expanding, evolving field that needs expertise, that protection of individual rights are vital. California's legal professional standard for legal excellence and ethical conduct in privacy-related matters, the benefits that organizations and consumers will have by increased confidence in this area. Specialists will be consistently trained and prepared to excel. And the fact of California being a technology leader, that position demonstrates a need for consumer and vendor protection. Then there is a description of what the proposed specialty area in privacy law would encompass, which would be a comprehensive curriculum covering these 5 key aspects that have been identified, including foundational knowledge, data protection compliance, data breach incident response, privacy litigation and dispute resolution, and emerging technologies such as artificial intelligence and the Internet of Things, and the impact of those on privacy and data protection. This part of the report concludes with recognition of the significance of this field and the importance of fostering the development of a specialized expertise in California in privacy law.
Thank you, Lindsay. As stated earlier in the intro welcome remarks, you will see in this section, in the next section, it's a bit of a forward-looking. So we are kind of giving hints to some of the topics that we will be discussing in part 2. If this exercise were to move forward, if CBLS were to agree with us that there is sufficient need and interest in privacy law and that the area of law is sufficiently defined to have specialization be useful, we will be discussing these. And so the way that this report is drafted, we do talk about key aspects as Lindsay presented. These are meant to be examples. And we will definitely be discussing whether these indeed are key aspects for the curriculum for the specialization in part 2. So keeping that in mind, again, that this is really meant to kind of start looking forward into our taskings for part 2. This is not set in stone, but it gives us some indications of where we're heading. Are there any comments, edits, or questions in this section?
I see no hands raised.
Thanks, Janelle. If not, we're going to ask Lindsay to give a presentation for the next section, which is the areas and themes explored.
So this next section, as Jiwon mentioned, there has been a significant amount of work going into this report, and this really reflects our last meeting and the data collected. So it starts out with a recognition that there are both benefits and challenges associated with developing a specialization in privacy law. And what the privacy law group reviewed was data including other states with privacy law specializations, bar associations and trade associations with privacy specialists, California privacy cases, enforcement actions with a privacy focus, and public interest and advocacy groups with a privacy focus. And we did conclude that there is a significant interest and compelling need for this specialty area. There is some detailed information here about the states who recognize or mandate privacy law specialization. And there's a variety of treatments. Some examples are included here. And while the data is varied in the different standards, we did find that it's clear that privacy law specialization is appreciated and supported by many jurisdictions across the United States. There were no less than 20 active local and national privacy associations, bar associations with dedicated sections and committees devoted specifically to privacy law. Cases with a privacy focus were reviewed, focusing on the last 3 years, and you can see some numbers here of cases focusing on CCPA, CMIA, and Invasion of Privacy Act. We reviewed enforcement actions with a privacy focus and 7 major domestic enforcement entities with some significant overlap in jurisdiction, which leads to some quite a bit of complexity here. The review of public interest and advocacy groups also supported moving forward with the development of a privacy law specification, and you can see a list of many of the groups identified here. We also reviewed, as Jiwon mentioned previously, privacy as a defined area of the law to ensure that defined specific standards could be created and maintained. And we found that that privacy is a defined area of the law, as mentioned in the history of privacy law above, and also 17 major law schools and colleges that teach privacy as a discrete topic. There are also quite a few committees and subcommittees at the legislative level here. So this part of the report concludes that there's a large and growing need for privacy law specialization and representation in California, a dedicated community of attorneys interested and devoted to privacy law specialization, an area of law being refined by state and national communities and interest groups, and support for the growth of privacy law as a field for the long term within the legal community and educational system.
Thank you, Lindsay. Again, I'm just so proud to see all of our work being reported out here, and I am tremendously grateful for each of you that have worked and put in a significant amount of time and effort in doing the research and making the presentations in our meetings. And so this is, all of our work that is really being packaged into this written format. And so thank you very much. I think this consulting group has just done a tremendous job in putting together the answers and the responses to the questions that have been asked for us to assess by the State Bar. If you have any comments or edits on this section, please raise your hand. If not, we're going to move on to the recommendations section.
I see no hands.
Okay, Lindsay, please take us to the next section.
All right, maybe this is the most exciting part, the recommendations. So we do recommend that the recognition of privacy law as a specialized area be developed. We are looking at benefits for both legal professionals, businesses operating in California, and consumers. We find that privacy law as a distinct specialty aligns with the principles of maintaining public trust, upholding privacy rights, and addressing emerging challenges in our digital age. So we strongly urge the California Board of Legal Specialization to approve the establishment of privacy law as a designated specialty area. And we recommend proceeding to develop this designation. And we sum up here with the rising and substantial demand for certified privacy expertise within the legal field, and the practical and highly sought after expertise.
Fantastic. So as you see here, each of our consulting group members, we will be listed, and this is the final recommendations that will be summarizing our recommendation to CBLS, recommending that we have found enough evidence that there is sufficient need and that the area of law is sufficiently defined. That will allow us to move on to the part 2, which is to look at the certification standards and some of the key concepts and the testing and the exam requirements that we have alluded to in terms of our next steps. As you know, we have been working together as a group for a little less than a year. I am just so grateful that we have come to this point where we can make a recommendation. I think the future was uncertain when we began, but I think we were able to work towards this goal and to finish the assessment with the help of our staff. I wanted to really highlight Adrian and Janelle's contributions here. Without them, we wouldn't be where we are today. So again, taking a moment for all of you to take a look at the recommendation section. Raise your hand if you have any comments or edits to make. If not, I will ask Lindsay to go to the next section, which is requirements for establishment of the privacy law specialization.
Okay, so the requirements that have been suggested here, I'll note that this is what staff has recommended, and it covers several key requirements that will need to be further explored. This is a list of sample requirements. First is curriculum regarding exam topic areas. The recommendation here is to explore topics from law school courses, sections, continuing education, course offerings, and their like. Secondly, there is a sample around sample requirement around exam development for privacy law. And an outline of the process is laid out here. This exam is aimed at determining what the minimum level of competence would be required to demonstrate expertise in privacy law. The process includes defining learning objectives, selecting topics, creating questions, designing questions, considering difficulty levels, including real-world scenarios, covering diverse content, avoiding bias, creating a clear structure, reviewing and editing, pre-testing, establishing grading criteria, considering time constraints, and making room for continuous improvement. Next, there is a suggested requirement to have minimum trial or practice experience. And the suggestion here would be to look at something very similar to other specialties under California law for the legal profession, which would be 5 years of legal work in the area and devotion of 25% of the time to practice in the specialty area. Factors that might be looked at here to look at the minimum experience would be foundational legal experience, an understanding of privacy law, privacy-related litigation or transactional experience, case or project complexity, level of responsibility, experience in negotiation and settlement, and some industry expertise. Lastly, there is a suggestion that we think about a requirement for peer references or review, and certain requirements could be developed for who qualifies as a peer for this purpose. This section ends with a recognition that, as Jiwon mentioned, the future state of privacy law may be changing. So we may face challenges such as keeping up with rapidly evolving technology, balancing individual privacy with societal interests, and harmonizing regulations across different jurisdictions. Additionally, addressing issues related to data breaches, surveillance, and the ethical use of emerging technologies like AI could pose significant hurdles for privacy legislation.
Thank you, Lindsay. So as Lindsay said, these are sample requirements and considerations for this group to consider as we go into part 2, if CBLS agrees that there is sufficient need and interest, and this is a sufficiently defined area of law. These are areas that we believe, the staff believes, are ways that other specialty requirements have been structured. So it's based on prior experience by the state bar. Now, I think I consider this consulting group's job, if we were to move forward with the next step, is to take a look at and assess whether these kinds of requirements and these kinds of considerations would be applicable, and whether that would be relevant, or do we want to make any changes and amendments to some of the stated requirements that were in place for the other specialty areas. So these are meant to be sample requirements with the understanding that this is generally how legal specialty is structured at the state bar for California. With that understanding and hoping that we can move forward to the next tasking, if the CBLS were to agree with our recommendation, are there any edits or changes to this section, requirements for establishment of the legal specialty in privacy?
This is Michael Isiri. I'm not sure if now's the time, but I understand that these are considerations. But I do have some comments on one or two of the proposed requirements.
Okay.
But enough for revisions for the purpose of the report for consideration.
Say that again, 1 and 2. So the curriculum and exam development, is that what you're referring to?
No, I didn't say that. No, I have 1 or 2 comments on the proposals sections. However, this is probably outside the scope of the proposed recommendations for the group.
Oh, so you want to go back to the recommendation section or this requirement section?
No, I don't think you get what
I think what he's trying to say is that he has some comments on the requirements, but then since we're not agreeing on the specifics of the requirements right now, we're just saying, well, those are ideas at this stage. I think what he's saying is that we are not going to be commenting on the specifics of the requirements now.
That's exactly right. So we are not, this again, this is what the staff recommends. This is how this legal specialty is usually structured. We will be discussing, and I think, in depth as we move on to the second part of our taskings, whether these are relevant, and this is indeed, what the group will recommend as the requirements for the new specialty area. Having said that, Michael, the floor is yours if you'd like to give some comment now.
Sure, I'll just provide some preliminary comments. Of course, nothing for revisions, and I'll be brief to respect people's time. I'm just focusing on the minimum trial or practice experience, subsection 3. It seems like it's a chicken or egg problem of how you can get that experience if you cannot get that experience. So even if you have the best intentions to follow or pursue it, the opportunities and pathways to pursue it is not available equally amongst everybody. Secondly, I'm looking at the peer reference and review. I know I highlighted some of the other organizations that have such a requirement. Again, it's more of a chicken and egg problem. But that said, those are the two main ones that I was a little bit skeptical to include as some of the recommendations. But as long as it's more of a higher epsilon of review and understanding that those are considerations, but not necessarily affirmation or confirmation of what we're going to pursue. Does that make sense?
It does. So let me give my thoughts in response, and
Yes.
I would love to hear the other members' thoughts on your points as well. So Michael, you bring up a really good point, and I think that's exactly what we're going to be discussing hopefully next year with the CBLS approval on December 8th. And once we, so just so you know, in terms of our kind of work order, I think we are almost at the end. So we have one section left for Lindsay to provide a conclusion, and then we're going to be voting on this on the whole. We're going to have a roll call vote. Everyone is going to say yay or nay in submitting this report. And then Janelle is going to tell us the next steps in terms of the timeline, in terms of when the CBLS meeting is going to happen, and what do we expect in terms of our part 2 work. So for Michael, what you are expressing, I think is a really good place to start. I think it is going to be our job next year, once we have approval on this, hopefully we have approval on this, to think about what is the specialist for? What does that mean? So again, this list of sample requirements comes from the other specialty areas, meaning the specialty by the California State Bar means that you have at least 5 years of experience. It is not meant for somebody who is just getting into this area of law. It is meant for somebody who has been doing this work already. Now, if the privacy consulting group wants to decide that the privacy specialty is going to be different, that it's going to be for somebody who doesn't have experience, who wants to get into privacy, I think that'll be a different way of looking at this. But I think it is important to note that for the other legal specialty areas in California, it is meant for specialists who already have experience and can demonstrate that you have been working in this area for at least 5 years. So that is really a different way of looking at it, right? I totally understand, Michael, that there might be some people that want to get some kind of certification, want to get education. I don't believe that's how the legal specialty works in the State Bar of California currently for the others.
If I can interject, this is Rob, having sat on the CBLS. So it doesn't mean you can't practice in the area, right? It's defining yourself as a specialist. And so
That's
that
right.
was why there. And I actually have a question for staff is, in terms of what the scope of what we're doing, because I know, again, having been on the CBLS, they're the guiding principles on how someone can pass the test questioning, the peer review and whatnot. How much influence do we have, and should we be making recommendations on that, or is that a completely separate conversation?
So
go ahead, Amy.
So I think this is something that we'll get to later, but I think here the report itself is intended to lay out the justification for establishing the field, and then also what are the considerations, which are the next steps for this team, and that is establishing what the qualifications should be for establishing yourself as an expert in privacy law. So that is defining these parameters, such as the level of experience, the level of peer review, or the exam itself, like building all of that. So here, these are ideas or considerations in determining what those qualifications should be. But it's not set in stone. It's just kind of setting up the parameters that need to be established eventually. We have more time to do that later.
And can they differ from the other specialties?
Yeah, they could, because there's already differential between certain specialties today.
That's what I wanted to understand, was that, can we create a higher standard or weaker if we wanted? But okay,
yes.
Thank you.
Sure.
Yeah. Ryan, I see your hand up.
Yeah, I just have a non-substantive edit. It looks like it goes A, B, C, E, F, G. So if we could add a D in there and fix the lettering.
Thank you, Ryan. Any other comments, questions, or edits in this section, the requirements section? If not, I'm going to ask Lindsay to provide a conclusion.
Okay, thank you. So this conclusion is a summary that via the report presentations that the privacy law group has heard, we do establish a need to move forward with a recommendation to adopt this as a new specialization to the CBLS for privacy law. There is a note here about State Bar Rule 3.166 subsection C that dictates that when the establishment of a new specialization area is made, the State Bar may approve for a period of no more than 2 years satisfactory completion of one or more alternative tasks in lieu of a written exam. And really this describes some next steps, which is, should the CBLS approve the recommendation to add privacy law as a specialty area, the PLG will need to recommend the certification, specializations, experience requirements, continuing legal education subfields, and the alternative requirements. And it closes here with a summary of a description of the demand for privacy law specialization and experts, a recognition of the challenges that do exist within this regulatory landscape, but the potential to wield a substantial influence and contribution to a more ethical and secure digital future.
Thank you, Lindsay. Please raise your hand if you have any comments, questions, or edits in the conclusion section. We'll give a minute, and if not, we're going to be turning to a roll call vote to approve the report.
No hands.
Thank you, Janelle. So at this time, I would like to recommend that the Privacy Law Group vote to approve the report of recommendation prepared by this consulting group. And we're going to be taking roll call for the report as prepared. So is there a motion and a call to approve the report?
So moved.
Yanaka, move call to approve.
Is there a second?
Hershenson.
Thank you, Robert. We're going to vote by roll call. Janelle?
Joy?
Hi, subject to adding that new number D to section 3. This is Soyeon Choi, and I vote to approve.
Thank you, Soyeon, for the reminder. I should say this is a vote to approve the report with the non-substantive changes that Ryan has made. Thank you, Soyeon.
Davis?
Approve.
Christensen,
Approve.
Isri,
Approve.
Tversky,
Approve.
Kalei,
Approve.
Karanian,
Approved.
Krolik,
Approve.
Lanoy,
Approved.
Martinez,
Approved.
Rajmahan,
Approved.
Serrato,
Approve.
Yanaka.
Approve.
The motion has passed. The report has been approved.
Congratulations, everyone. We now have a report that has been approved, and we will be submitting this to CBLS. We're going to be moving to agenda item number B, which is the discussion on the next steps for the privacy law group. The next CBLS meeting that this report will be presented at is scheduled for December 8th. The staff is going to let us know when and where, whether it's going to be remote, whether it's going to be in person. That has not been decided yet. And we're going to get further information about when and where so that we can participate in the presentation at CBLS. The PLG officers and Lindsay will attend the CBLS meeting to present the item and to answer any questions. If the proposal, our report that we have just approved is approved by CBLS at their December 8th meeting, the privacy law group will be undertaking the next 4 items here, as you see here on the screen, which is to research, discuss, and create the exam specifications. We're going to be discussing and creating the experience requirements, which we talked about briefly today. Also discussing and creating the continuing legal education subfields, and then to create the alternative non-exam pathway requirements. Those are the 4 taskings that we will have if we were to receive approval at the December 8th meeting. Also, please put into your calendars for the next privacy law group meeting, which is set for Thursday, January 25th. We're hoping that we will have good news on December 8th and that we will have a substantive agenda for us to work on starting from the January 25th meeting in 2024. Those are the next steps for our group. Any questions or comments? I do have some reminders here and an update on the Badgley-Keene Open Meeting Act. The governor signed SB 143, which temporarily, through the end of this calendar year only, restores the ability to have remote or hybrid meetings without noticing locations. Starting January 1, we will have to move back to meeting remote, either participating remotely, and if you are participating remotely, the advisory body has to provide a means by which the public may hear audio of the meeting or remotely observe the meeting. The public must be able to attend the meeting and provide public comment at the noticed physical location. The noticed location must be compliant with the Americans with Disabilities Act, ADA, including bathrooms. The agenda must be physically posted at the noticed physical location. Upon discovering that a means of remote access has failed, the state body must end or adjourn the meeting. All of this is true if the exemption that we had currently is not extended. So the staff will let us know for the January meeting if we're going to continue to hold these meetings in remote and or in hybrid fashion, or if we will be meeting in person. So please do look out for updates between now and January about these meeting requirements. And do reach out to staff if you do not have access to a location that would comply with the Badgley-Keene Open Meeting Act policy. Any questions about the Open Meeting Act policy? Okay. Any other questions or comments?
I guess I just want to again thank the staff. Thank Ryan and Lindsay for sure for putting everything together with the staff. June, I want to also thank you for winning this. No, I just want to provide thanks. So thank you.
Thank you, Michael. This concludes all open session items. There are no closed session items on today's agenda. I hereby adjourn today's meeting.
Thanks, everyone.
Thank you.
Thank you, everyone.
Thank you.
Thank you.
Thank you.